Good afternoon and welcome to the afternoon session of the Court of Appeals. Your panel today, to my left, Judge Carmen McGee from Savannah. To my right, Judge Kenny Armstrong from Memphis, and I'm Arnold Golden from Memphis. Do we have any announcements? Or?
No, Your Honor.
All right. You may call the first case.
City of Milan, Tennessee, et al. Versus Frederick H. Agee.
You can reserve up to 5 minutes of your time.
Excellent. Thank you, Your Honor. Can I reserve 3 minutes?
All right.
Good afternoon, Your Honors, and may it please the Court. Matt Cloutier here on behalf of District Attorney General Agee. This Court should reverse the trial court's decision for 2 reasons. First, the trial court erred in its interpretation of Section 87103. It ignored critical language in the text, disregarded evidence of contemporaneous interpretation and understanding, and misconstrued the legislative history. Second, the court also erred by granting a writ of mandamus. The court acknowledged at the outset that prosecutors have broad discretion about how they go about their jobs, including the ability to choose whether to bring prosecutions at all. Even so, the trial court concluded that the district attorney here had a non-discretionary duty to prosecute cases in the municipal courts. Because these decisions cannot be reconciled with the well-settled rules of statutory interpretation or the equally well-settled limits on the writ of mandamus, this court should reverse. I'd like to start with the statutory interpretation question and note that every tool of statutory interpretation we have at our disposal confirms that this statute does not compel the district attorney to prosecute cases in municipal courts unless the municipalities provide personnel for that specific prosecutorial purpose. Now, interpretation, as this court is well aware, should always start with the text and with the plain meaning of that text. And here, the plain meaning of the statute strongly supports the district attorney's position and requires reversal. Subsection 1 is the first subsection of the statute I'd like to talk about, and it provides that each district attorney shall prosecute in the courts of the district all violations of the state criminal statutes and perform all prosecutorial functions attendant thereto, including prosecuting cases in a municipal court. And here's the critical language: where the municipality provides sufficient personnel to the district attorney general for that purpose. And there's 3 things I'd like to pull out from the statutory language that I think are helpful to understand the statute and to understand where the trial court went wrong. The first is that it says for the duty to be triggered, a municipality has to provide sufficient personnel to the district attorney. Now, we understand this to mean that the district attorney should receive something from the municipality. And I think this helps to understand why the trial court was wrong to point to the provision of court personnel under the statute, because those personnel, I think, municipal judges, court clerks, and bailiffs are not provided to the district attorney. To the extent they're provided to anyone, it's to the public at large and to defense attorneys just as much as to the prosecution. The second thing I'd like to emphasize about the statutory language here is that the provision specifies what the municipality has to provide, and that is personnel for the purpose of prosecuting cases. Now, under Tennessee law, we think this necessarily means prosecutors because, as I think everyone here agrees, nobody else is able to prosecute violations of state law. And I think, again, this highlights the problem with pointing to other court personnel, because personnel like municipal judges, clerks, and bailiffs cannot prosecute cases and certainly aren't supposed to pick one side or other in a particular case. Instead, they're neutral arbiters in the case of the judge and not part of the decision-making process at all when it comes to the other personnel. The third and final thing that I'd like to highlight from the statutory language is that the provision also makes clear how much personnel the municipality has to provide, and that is sufficient personnel to prosecute cases in the municipal courts. Now, I want to be clear, I don't think this court needs to get into the weeds of what exactly might be sufficient in this case, because everybody agrees that no personnel were provided for the purpose of prosecution.
Let me ask you, isn't there a statute that creates the District Attorney General's Conference, and each prosecutor has to make an application for the number of assistants that they say they need to operate their office? In this case, did the district attorney apply to the conference? And in that application, did he include these 2 municipal courts?
I do believe he applied for the conference, but if I'm understanding Your Honor correctly, I think you're asking about the provisions in Title 16 that the trial court relied on. Is that correct?
Well, I don't know what the trial court relied on. I don't know if the trial court even discussed this, what I'm asking you now.
Sure.
But I do know that the District Attorney General's Conference determines or decides the number of assistant DAs needed for each district. And my question is, did the DA in this case apply, and did the conference decide what number of assistants he needed?
I do believe he applied. I don't recall, to your earlier question, whether he specifically singled out these two municipalities as a need for additional prosecutors. I know he was not given the number he asked for. But I do want to point out, if we're talking about Title 16, or even if we're not, Title 16 makes clear, among other things, that nothing in this section or any other provision of law should be construed to prohibit or prevent the employment of additional ADAs in a particular district. And again, here's the critical language: regardless of whether the positions are funded by a state or non-state source, or whether they are specifically enumerated in this section or any other provision of law. So I think the General Assembly has been clear that, while it might establish a baseline number of prosecutors for a certain district, or it might enable prosecutors to seek additional positions through the District Attorney's Conference, nothing in Tennessee law should be construed to prohibit non-state funding sources to create additional positions as needed. So we think that kind of dovetails nicely with our interpretation of subsection 1 of 87103.
Well, in 87302, that gives the conference the authority to determine the number. And so they're deciding that this is the number of prosecutors needed in this district. The other statute that requires the municipalities to provide sufficient personnel, why would that necessarily mean prosecutors?
I think that takes me back
to... If they wanted to include prosecutors, why didn't they just use that language? Prosecutors and other clerk or court personnel, but they don't say prosecutors at all.
They don't, Your Honor. They certainly could have been more specific, but I think, again, as we explained in our brief, we think the most natural reading of personnel for that purpose, which is the exact statutory phrasing referring back to the purpose of prosecuting cases, can only be read to refer to prosecutors or people who are necessary to that actual act, not, neutral court personnel, for instance, like that the cities have provided here.
Okay.
So I think, that's subsection 1, which we think provides an independent basis for reversing the trial court's decision here, because it at most imposes a contingent duty to prosecute cases in municipal courts when personnel, again, are provided for that specific purpose. But I also want to touch on subsection 6, which we do think provides an independent basis for reversal here. And to understand why, I think it's helpful to take a step back and look at section 87103 as a whole. So that section establishes, again, as I think everybody here agrees, a range of duties for district attorneys, including the ones that we've discussed in subsection 1. But towards the end of that statute, we have subsection 6, which says, among other things, that DAs, quote, shall have discretion in the performance of duties and responsibilities. And once again, the key language comes later, but it says any other law notwithstanding. Now, courts have consistently recognized that when a statute includes a notwithstanding clause like this one, it does it to denote that one thing controls despite or in spite of another thing. In other words, these provisions show which prevails in the event of a conflict. So the takeaway here is that section 87103 as a whole establishes a range of duties, but subsection 6 confirms that none of those duties can override the discretion that courts have long understood is inherent in the role of a prosecutor. And again, I think this highlights a problem with the trial court's analysis here, because the trial court, as it has to, it tried to give some effect to this provision, and it said that maybe it was just an attempt to codify the common law discretion that prosecutors have always had. And I think that's exactly right, but it, if anything, cuts in the state's favor here, because it confirms that these prosecutors have the ability to choose whether to prosecute at all. And we think that greater power to choose not to prosecute necessarily encompasses the power to choose not to prosecute in a particular court.
And let me ask you this, why is that not an overly broad reading of that section? Because if you're saying they've got the discretion not to prosecute at all, well, if you follow that line of reasoning, would they not have the discretion not to do, basically to just do nothing?
They might, Your Honor, but the accountability for prosecutors doesn't come from courts, applying the writ of mandamus like here. Instead, it comes from the political process or through the impeachment process. Our state has a way to hold prosecutors accountable if they choose to simply not do their jobs. That's either voting them out at the ballot box or going through the process of impeachment if they're truly declining to do anything at all. But again, I think it really underscores the reasons why courts shouldn't be getting engaged in this kind of political question, which has long been reserved to a different process altogether. And, again, I think you're right, Your Honor. It is a broad reading, but I think that's sort of the purpose of these notwithstanding clauses, is to confirm that this does trump other statutory provisions that might be understood to conflict in the abstract. And I think to sort of illustrate this, subsection 1, the one that we've kind of focused on this morning, or this afternoon, I apologize, includes the word shall and could be read to impose a mandatory duty to prosecute every possible state law violation, but we know that can't be right. I mean, we know district attorneys' offices have limited resources and have not and cannot prosecute every conceivable violation of the law. So I think subsection 6 exists to ensure that nobody reads that as a mandatory, conditionless duty, but instead as one that is ultimately subject to the district attorney's discretion. And with my remaining time, I do want to quickly touch on the writ of mandamus. And I think at the outset, I want to note that if this court agrees with us about either of the statutory interpretation questions, either under subsection 1 or subsection 6, I think the court has to reverse the mandamus decision here. Because either we're dealing with a conditional duty, which I think mandamus wouldn't be proper for unless that condition has been met, and everybody agrees here that prosecutors have not been provided by the municipality. And if we're dealing with subsection 6, then we're talking about a discretionary duty, which mandamus cannot be used to compel. I think as the Tennessee Supreme Court has been clear on for, I think, well over 100 years, mandamus does not lie to compel a discretionary act, but instead can only be used to compel purely ministerial duties that are clearly established. So again, I think this really, underscores the problem with what the trial court did here, where it acknowledged at length that prosecutors have immense discretion, again, including the ability to choose not to prosecute at all. The trial court here quoted at length from the Tennessee Court of Criminal Appeals, where it said, quote, "There are no statutes which govern the exercise of prosecutorial discretion in determining whether, if at all, criminal proceedings are to be instituted." It also quoted from the Tennessee Supreme Court saying that district attorneys have, quote, "virtually unbridled discretion in determining whether to prosecute and for what offense." But while it acknowledged that on the one hand, it still somehow found a non-discretionary duty to prosecute in municipal courts on the other. And we don't think there's any way to reconcile those two conclusions, that both mandamus is proper, but district attorneys have this level of discretion. So we think that, again, compels reversal here. And if I can just briefly conclude, unless the court has any further questions, I'll say that the plain text of section 87103 should be more than enough to resolve this case in the district attorney's favor, either under subsection 1, concluding that it's a conditional duty, or under subsection 6, concluding that it's discretionary, or both. Again, we think it creates at most this sort of contingent discretionary duty to prosecute cases where the municipalities provide personnel for that purpose, and because that has not happened, we think this court should reverse on statutory interpretation grounds and should reverse on the writ of mandamus as well. Thank you. I'll reserve the remainder of my time.
Hear from the appellee.
Good afternoon. Michael Carter, City Attorney for the City of Milan. I have with me Mr. Mike Hill, representing the City of Trenton in this case. I'm going to address some of the issues and then, with the court's permission, yield the balance of my time to Mr. Hill to address the balance of the issues.
How much time are y'all setting aside for each?
About half.
Do you want 8 and give him 7, or do you want 7 and give him 8?
I'll take 7. Please.
All right. Thank you.
Thank you. It makes it so much easier. 87103, the statute at issue in this case, cannot mean to pay the DA. If it meant that, which is what the state contends that it means, then we, all of us, would be able to know how much we owe. You cannot discern from 87103 or any other law how much that ought to be. That's important because it sheds light on the meaning of 87103. The state says that the District Attorney General gets to decide how much the cities ought to pay, as if he has that authority, but he simply does not. He's a creature of statute, not of the Constitution. The General Assembly prescribes the limits and the responsibilities on the power of the District Attorney Generals. The General Assembly has not given the District Attorney the power to impose what would essentially be a tax on the citizens of Milan or Trenton to pay whatever arbitrary, reasonable or unreasonable number the District Attorney General thinks in his unfettered, as they say, unassailable discretion. Unassailable discretion is what they say, unchecked by any other authority, to impose a mandate on the City of Milan and the City of Trenton to pay whatever number he says. 87103 has mandatory language in it. It says shall, and in this context, shall in fact means shall, must, a ministerial function. how the District Attorney General prosecutes, he has discretion. We're not asking the court to determine how the District Attorney General prosecutes a case or all of the myriad of cases that the District Attorney General handles. That's not our prerogative at all. How he handles his cases is really up to him. He does have that broad discretion, and there are a legion of cases that say that. But the shall in the statute doesn't say shall prosecute in a certain way. It's shall prosecute, which means show up, do your job. How you do your job, that's your discretion. He has an immense amount of discretion in that regard, but not the discretion on whether to show up. And that is what we sued him to do, was to show up and do his job in our respective municipal courts. The state argues that Section 6 of this same statute swallows whole all of the rest of the statute. What they miss is the plain language in Section 6. Section 6 says that the District Attorney General has the discretion in the performance of duties, and it goes on from there. The performance of the duties, not what the duties are. And so we don't argue with the state or disagree with the state that the District Attorney General does, in fact, have broad discretion in the performance of his duties. Where they fail, though, is they contend that the District Attorney General has the authority to say what his own duties are. Only the General Assembly has that. 87103 cannot mean prosecutorial personnel. That is a forced and strained interpretation of the statute, adding additional language that is not there. The cities of Milan and Trenton cannot hire state employees. It's pretty obvious. Only the District Attorney General, as the state contends correctly, can anoint or appoint, bless, approve Assistant District Attorney Generals. The cities don't have the power to do that. So when the statute talks about sufficient personnel, it must mean municipal personnel. Those are the only personnel that we can employ. And it's undisputed that our respective clerks, deputy clerks, bailiffs, and police officers who provide transportation of incarcerated citizens accused of crimes are sufficient for the purpose that they serve. There's no dispute about that. What the state wants you to interpret 87103 to mean is that we have to provide funding. We have to provide money for them to hire their personnel. That's a lot of extra words laid on top of a statute that simply doesn't mean prosecutorial personnel. When it says personnel, it must mean the only personnel that we can provide. When the General Assembly wants...
Are you suggesting that the municipalities can't hire prosecutors?
Yes, sir. I know it happens in other places, but what happens in other places, and this is in the record, there are some cities that have, I believe, municipal employees that serve at the discretion of the duly elected District Attorney General, and they are sworn in, take an oath to that office. And so while they may get a W-2 or a 1099 at the end of the year from their respective municipal organization, they are essentially employees of the District Attorney General. And the key thing to know there is those are symbiotic relationships where those cities and those District Attorney Generals agree to do it that way, which is totally different than our situation. Here, we cannot go out and hire our own person to prosecute cases. That person would have to be, and the state's correct about this, and we don't disagree, that person would have to be approved by the District Attorney General. He rightfully has the say in who that person is and would have discretion on whether that person is sworn in to prosecute cases on his behalf.
Is there any requirement that the personnel that you would be hiring to prosecute would be required to earn the same salaries and benefits as someone who's hired by the Attorney General, or could the municipality hire someone at any particular salary that it chose to provide benefits that it chooses for other city personnel, and then make arrangements with the Attorney General to use those people to prosecute cases?
Yes, sir, and that may be happening in different places, but those, again, are agreed arrangements where the city and the District Attorney General, for their own reasons, elect to do it that way. And we don't take a position on that. If I had to take a position, that may in fact not be legal, but that's not really determinative of the issues in this case, because we don't agree that, like in other places where the cities agree with the District Attorney General's office to do that, we don't have that type of agreement in place in our situation. When the General Assembly wants to impose an obligation for cities and counties to hire an additional assistant DA, they say so. It's in Title 16.
Maybe I'm missing something, but it seems like the controversy here is that y'all don't want to hire prosecutors, and the Attorney General is saying that we're not going to prosecute, but if you hire prosecutors, then we will prosecute. Am I missing something?
A little bit. It's essentially that the District Attorney General takes the position that we ought to provide his office funding for a prosecutor, which is essentially the same thing, whether we're paying a person who's a city employee or we're paying a person who's or some portion of a salary of a state employee. It's all about the money. How it's structured essentially doesn't matter. It's still a person who works at the discretion of the District Attorney General.
Well, it may make a difference in the sense that the Attorney General may have to pay a certain salary to someone where the city could pay a lower salary, for instance, than the Attorney General's office would have to pay to hire someone to do that. So, I mean, is that something that is feasible? Do you understand what
I do, but that would be in a
I'm not
situation.
understanding it just to be providing funding, I guess is what I'm saying. It's to provide personnel being prosecutors.
Right, but it would be something that would be forced upon the city, and the statute simply doesn't have that mandatory forced language that we have to go out and pay for prosecutors. That is what the state contends, is that
I guess that's what this is about.
Yes, sir, that's the root issue, is do we have to pay for prosecutors? And there's no statutory requirement to do that, and when the General Assembly wants that, they say so. They say it in Title 16. Thank you, Your Honor.
Let me ask you
Yes,
this.
sir.
I asked this earlier about the number of assistant DAs authorized for General Agee. Do you know whether or not in his application for assistant DAs, he included your municipality or not?
I don't know that that's part of the application process. It would certainly be implicit because he covers many courts, and our courts would be included in the number of courts. I think there's some 13 or 15 courts in the 28th district, and so whether they're spelled out in that application or not, I can't speak to that. What I can speak to is General Agee asks for a certain amount of not only prosecutors but other state employees to which his office is entitled, and then there's a sort of a vetting process through the conference, and the conference determines how many he ought to get. He has more now than he's ever had. Title 16 says he's entitled to 5. He has 8. That's what I can speak to for sure.
Okay, all right.
Thank you, Your Honor.
Good afternoon. Michael Hill from Gibson County here on behalf of the City of Trenton. I'm going to hit some of the points that Mr. Carter did not hit. Some of what the General Agee talks about is Attorney General opinion supporting their proposition. The appellant argues that Tennessee Attorney General Opinion 01120 supports the proposition that TCA 87103 requires the city to provide more than sufficient personnel, as mentioned in the statute, and that they must provide additional prosecutorial personnel. In the analysis portion of the opinion, the AG stated that a District Attorney General only has the responsibility to prosecute where additional personnel are provided to the District Attorney. The word additional in that opinion was added to the opinion. That's not in the statute. The opinion does not indicate that additional personnel shall be prosecutorial personnel, as the appellant avers. Accordingly, the AG adds the word additional to personnel to opine that the district attorney only has the duty to prosecute state criminal actions in municipal courts if additional personnel is provided. As noted, the word additional is not in the statute. Additionally, the appellant told this court on page 23 of its brief that the Attorney General concluded that the duty to prosecute was only triggered where additional prosecutorial personnel are provided to the District Attorney General. The appellant adds the word prosecutorial to the quotation from the Attorney General opinion that does not appear in the opinion. The appellant misquoted to this court what the Attorney General opinion says. The addition of the words to the statute by the Attorney General and the appellant demonstrates the lack of reliability of that opinion. Appellant also asserts that Agee Opinion 00242 supports the proposition that district attorney generals are not required to appear and prosecute all criminal cases in a municipal court as a result of, quote, complete discretion, pursuant to TCA 87106 or 1036. The word complete is not found in that section. The AG rendered this opinion despite the language of 87103.1 that indicates that a district attorney shall prosecute if a municipal court provides sufficient personnel. Also interesting, in an Attorney General Opinion 07157 in 2017, the Attorney General stated there was an issue that came up about prosecuting notaries for things that they did wrong. The Attorney General stated that pursuant to TCA 87103, the district attorney has the duty of prosecuting all violations of state criminal statutes which occur in his or her district. There's no qualifying language that if they feel like it or they want to and things like that. We realize they have discretion. I'm just pointing out that when they say that the Attorney General's opinions support what they say, it's just interesting the AG's opinion is saying that they have a duty to prosecute all violations of criminal statutes which occur in their district. We talked a little bit about the voluntary practices of these other jurisdictions that are in the record. They talked about other jurisdictions where they have either paid or provided an attorney. But the record shows that all those attorney generals and those municipalities are doing that voluntarily. There's no indication that they were doing it because they believe that it's provided under 87103. General Mulroy from Shelby County said he has no knowledge of whether they have a written agreement with the municipalities and doesn't even know how the arrangement started. General Goodman stated that they changed from paying part-time to paying full-time, but that occurred before he took office, so he has no idea how it originated. And then General Pickens from the city of Jackson, they have an agreement, but he testified it predated him and predated 87103. So these other jurisdictions that have these arrangements where they do, the state wants to argue, well, this shows that we must do it. No, it doesn't. That just shows that they're doing it voluntarily. They want the court to believe that that evidence is how 87103 should be interpreted. It has no bearing on that. We argue that the broader statutory scheme supports the trial court's ruling. We aver that the general purpose of 87103 is to provide legislative directives as to the duties expected from the position of the District Attorney General, and that such is plain, without adding any verbiage, as the appellant wants to do, or restricting the scope. The plain language of the statute indicates the role of the District Attorney General shall be to prosecute in all courts of their district. Absent sufficient personnel provided for him to perform his prosecutorial duties, the duty is not relieved. Appellant would have this court to adopt a version of the statute which includes additional verbiage which suits his purpose and includes the word prosecutorial before personnel. That is not in the statute, and it's not even inferred in the statute. The statute specifically speaks of a municipality providing sufficient personnel. Our position here and at the trial court was we're providing sufficient personnel that's provided under the statute, and that's our court personnel. And there's also an issue about the legislative history. The appellant introduced the legislative history from Senator Rochelle, who was the sponsor in the Senate for this bill. He was asked a question by another senator if the bill will give local district attorneys the authority to stop prosecuting cases in municipal courts if they feel they don't have enough staff to prosecute. That was a question during their debate. His response was, quote, yeah, basically, I think that's it, close quote. They argue that supports their interpretation of the statute. However, our position is that an individual legislator's comments on what they think the bill says is not a substitute for what the bill actually says. Despite Senator Rochelle thinking that's what the bill meant, the bill that he sponsored doesn't say anything about paying the DA. So the statute simply does not say what Rochelle thinks it means, and there's no discussion about what pay would mean or what it would even look like. There's no direction. That's why we say That's why the statute doesn't require the pay or the provision. If that's what was designed for the statute, it would have said that. Pay the DA or provide a DA. It says provide sufficient personnel. It doesn't say prosecutorial personnel or anything like that. Also, interestingly, in the House, Representative Hargrove was the sponsor there. He had 4 opportunities to discuss the bill through committees, the House Judiciary Committee, and he indicated that the bill was to streamline some of the duties that the prosecutor had historically had, and that other officers were doing, like the controller now. He said that multiple times, that bill was just to take away some of the duties to match what actually occurs. In 4 times that he spoke on the House floor about these, either in committees, for the full floor, not one time did he say that this bill was designed that the municipalities had to pay the DA for them to prosecute. So that's why we say that this stray comment that Rochelle thinks that's what it means is of no help. Again, if it meant pay, the statute would have said pay. We urge the court to uphold the ruling of Chancellor Mansfield. Thank you.
Just a few quick points on rebuttal, Your Honors. I want to note at the outset that my friends on the other side, much like the trial court below, have not meaningfully engaged with the statute's requirement that the municipalities provide personnel to the district attorney. Again, we think that undermines the interpretation they've advanced here, which suggests that court personnel are enough. They also don't engage with the idea that the statute says that the personnel have to be provided, quote, for that purpose, which again is prosecution. We again think that that undermines the idea that you could simply provide court personnel, which would effectively mean that as long as a municipal court exists and has personnel to operate it, then the DA has a duty to prosecute there. That's not what the statute says, and if the legislature wanted to say that, it certainly could have. But it instead directed these municipalities to provide personnel to the district attorney for the purpose of prosecution. Now, I know my time is tight, but I do want to quickly address the Attorney General opinion, since that was a big point of discussion, but from my friends on the other side. You know, there's 2 Agee opinions here, and I'll note at the outset that we acknowledge that these opinions are not binding, but the Tennessee Supreme Court has said that Attorney General opinions are entitled to considerable deference, and we think that's especially true here because of the doctrine of legislative inaction, which the Tennessee Supreme Court has said basically means that if you have an interpretation of a statute and the legislature declines to do anything to correct it, that's persuasive evidence that the legislature has acquiesced in that interpretation. Now, I'll be clear, that doctrine is typically applied in the context of a court interpreting a statute, but the Attorney General the Tennessee Supreme Court in 2019 in Coffee County Board of Education versus City of Tullahoma, which is cited in our briefing, said that this doctrine can be applied to Attorney General opinions as well, and it did so there. I think my friends on the other side have kind of, chosen to fly-spec these opinions and suggest that they've, erred by including additional wording that's not in the statute. But we think this misunderstands the role of Attorney General opinions, which are to interpret statutes, not just to copy and paste their language. The Attorney General, I think much like we have here, read the statute to require that personnel be provided to the district attorney. Sure, the statute doesn't say additional, but I don't see how you could provide personnel without it being additional to something or more than 0. We think that the plain meaning of additional and the plain meaning of the statute get you to the same place, which is providing more personnel than the municipalities did here. Now, I also want to quickly touch on the legislative history. We don't think the court needs to get there. I think this court is well aware of the pitfalls of relying on legislative history. But on the one hand, we have statements from the Senate sponsor saying that this is what the statute does, that align with our interpretation. And on the other, we have silence from the House sponsor. So we think if you're going to rely on the legislative history at all, the statements from the Senate sponsor have to trump the silence. But of course, we think the plain text of the statute is enough to resolve this case. And if I can, I just want to leave this court with one thought, which highlights, I think, what the plaintiff's position is here. As they read these statutes, the DA has to prosecute all violations of state crimes in municipal courts and in the other courts in their jurisdictions. If that's right, I don't see how prosecutorial discretion has any meaning at all. I think if the DA has a non-discretionary duty to prosecute every case, that is both legally untenable and practically impossible. For these reasons, we would ask this court to reverse. Thank you.
Thank you, counsel, for that very interesting argument. We will take the matter under advisement and issue our opinion as soon as possible. Thank you. Free to go. Any more cases? All right, please adjourn until the call of the docket tomorrow.
All rise.